It's Michael Popok, Legal AF. Alina Habba missed a legal precedent from 1919 when she improperly misdirected the jury in her opening, claiming that Donald Trump has a mitigation of damages defense and that the burden is on E. Jean Carroll, the victim of his rape and of his defamation. The burden is on her, according to Alina Habba, to prove that she has mitigated her damages or that she has an obligation to try to lower the amount of damages by her conduct. Unfortunately for Alina Habba, that's completely contrary to case law dating back to 1919, emanating from the highest court of New York, that is the binding courtroom, binding precedent for this particular case that's playing out again in the second E. Jean Carroll punitive damage case that's going on right now in federal court. Let me do a Legal AF breakout session, law school breakout session of mitigation of damages and why courts don't generally put the burden on the victim of defamation, where actual malice has already been proven and established by a jury and a judge, doesn't put that burden squarely on the shoulders of the plaintiff. It would turn the law of defamation upside down if the victim of the defamation has to continue to stay quiet and not go and publicly try to refute the defamatory statements. Because Alina Habba's arguments to the jury was she went on television, she went on CNN, she didn't mitigate her damages. She exacerbated her damages. She amplified the injuries by making herself a public victim. That was the argument. Now, I was a little surprised that Robbie Kaplan, who was a tremendously skilled litigator on behalf of E. Jean Carroll, didn't jump up and down, ask for sidebar, interrupt the opening statement. I mean, you don't like to interrupt opening statements for your adversaries, but when they're misstating the law and misstating defenses that they've never raised in the case before, you have an obligation to raise your defenses prior to trying to introduce them to the jury. She sat quietly, but she's handling it now in a brief that the judge has asked for about whether mitigation of damages is even a defense to an actual malice defamation case or not, which it is not under New York law, and what to do about it. Well, we have the new filings. Got one hot take going up by Ben Meiselas, my colleague, who's going to talk about what Alina Habba is arguing as to why she misstated and mischaracterized the law and misled the jury in her opening, and why she found some sort of case law to argue that mitigation of damages is appropriate in a defamation case. But then I got to rely on what has been filed so successfully so far by E. Jean Carroll's law firm, Kaplan Hecker law firm, in which they very clearly point out to the judge in answer to his question that ever since 1919, that's not an obligation of a defendant, and that there now should be an instruction to the jury before closing or at the time of the closing of this case on Monday or Tuesday of next week, what we call a curative instruction. It cures a problem, telling them that everything that Alina Habba said was incorrect, should be ignored, that the judge is the lawgiver in the case, not Alina Habba, that when she made her statements about defamation and a defense of mitigation of damages, she was plain wrong, and that the jury needs to be so instructed to cure the damage caused by Alina Habba. We're just watching, as I've said before, a monkey on roller skates. Alina Habba having no clue on how to practice law in federal court and how to try cases. It's obvious every time she stands up that she doesn't know what she's doing. And here's yet another example. Let me break down what's in the actual brief that's been requested by the judge, submitted today. Today was a day when the trial was dark on purpose, no testimony taken. They'll resume on Monday with a couple of witnesses, maybe Donald Trump. He keeps threatening to testify, usually doesn't at all, and maybe another witness on behalf of the defense. But here's the issue, the legal issue. So, pull out your pads. We're about to do Legal AF Law School, YouTube style. In 1919, the case by the highest court in New York, which is the Court of Appeals, is a case called Den Norsk versus Sun Printing. In that case, the court, and it's never been changed, found that there is no obligatory burden for victims of defamation and other intentional torts to avert the injurious consequences, to mitigate damages, to diminish the harm to themselves for that defendant's bad misconduct, right? They don't have an obligation as a victim of defamation or intentional tort under Den Norsk line of cases since 1919 in New York to mitigate damages. And the fact that she, E. Jean Carroll, to try to reclaim her dignity, reclaim her her authenticity, her truth, and to refute and reject the lie against her, right? As a rape victim, the fact that she, in order to do that, people grieve in different ways, people reclaim their integrity in different ways. The fact that she did it by going on television and talking about what happened to her and saying that what Donald Trump and his followers said about her was untrue. That's not only not inappropriate, it's appropriate. And she doesn't have to worry about whether she's mitigating damages or not by drawing new attention to the wounds caused by Donald Trump. We all have a heartfelt reason to support our blood pressure. In fact, more than half the U.S. population would benefit from blood pressure support. Super Beets Heart Chews are an easy and convenient way to support healthy blood pressure. And they promote heart-healthy energy. Paired with a healthy lifestyle, the antioxidants in Super Beets are clinically shown to be nearly 2 times more effective at promoting normal blood pressure than a healthy lifestyle alone. And with over 30,000 5-star reviews and counting, Super Beets Heart Chews are having their moment. Super Beets Heart Chews are incredibly delicious and so much better than any alternative supplements out there. I take my Super Beets Heart Chews each morning, and it's really kick-started my morning routine. Super Beets is the #1 doctor, pharmacist, and cardiologist recommended heart chew for cardiovascular health support. It's blood pressure support you can trust. Double your potential with Super Beets Heart Chews. Get a free 30-day supply of Super Beets Heart Chews and a free full-size bag of turmeric chews valued at $25 by going to legalafbeets.com. Get this exclusive offer only at legalafbeets.com. And that when Alina Habba stood up in front of that jury and said the following, this is from the opening statements, day 1 after jury selection from Alina Habba, misstating the law. I need you as a jury to remember this. Everything I'm going to say after that, she misstates the law. And this is very important. Miss Carroll had a duty to minimize the effect of the statements, right? The defamatory statements by Donald Trump, not to exacerbate them, as I will show she did when she ignored that duty and did the exact opposite and still does today. That's wrong. There is no duty on the victim of an intentional tort of defamation with actual malice to do anything. And if she wants to go on CNN and talk about it with Anderson Cooper and reclaim her story, reclaim and remediate her injuries, she's fully allowed to do that. In fact, as the Supreme Court has explained, the U.S. Supreme Court has explained in a case called Gertz from 1974, the first remedy for any victim of defamation is self-help, using available opportunities to contradict the lie. That's exactly what E. Jean Carroll has done, and what Alina Habba has now convinced the jury in her opening is wrong, when it isn't. And that's where the curative instruction to the jury from the judge has to come before they start to deliberate. Besides the Den Norsk case, the brief goes on to say, the new brief that was just filed, and this is very interesting, is this goes to the failure to properly conduct yourself professionally as a officer of the court. I'm talking about Alina Habba now. They say that, as Your Honor has previously noted, this is the lawyer for E. Jean Carroll to the judge, Mr. Trump, quote, has slow-rolled his defenses, asserting or inventing a new one each time his prior effort has failed. That's an observation by the court in the prior case. Mr. Trump, now this is not going to shock you. Here's another example of Alina Habba screwing it up, right? Screwing the pooch and waiving defenses. Mr. Trump did not raise failure to mitigate during his prior attempts to assert new unpleaded defenses. Accordingly, Ms. Carroll would be substantially prejudiced by allowing Mr. Trump to assert a new affirmative defense mid-trial. This goes on to say that Alina Habba, for instance, was actually the one who has coordinated and developed all of these strategies in the case. She was the original attorney before being replaced by Joe Tacopina, and that's something that Robbie Kaplan doesn't want the judge to forget. We have no one to blame but Alina Habba. In fact, she says on page 3 of the brief, not only did Alina Habba design all that, but Miss Carroll designed her litigation discovery and trial strategy based on an understanding of what were the prevailing defenses, and mitigation of damages was not one of them. And so now that the judge has received both filings, Alina Habba's briefing on the issue and the curative instruction request by E. Jean Carroll's lawyers, I expect soon, before this weekend is over, for Judge Kaplan to rule in favor of E. Jean Carroll and find she has no mitigation obligation, and to then do a curative instruction to say everything that person just said to you in opening statement about the law of duty of mitigation is wrong and false. I am the lawgiver. I wear the black robe. You are to reject that, and here's the curative instruction. Another screw up by Alina Habba, for which they will jump up and down with their hair on fire and claim mistrial for the third time in the case. Oh my God, the judge is against us. The judge is against you because you're wrong on the law and the facts almost every time when it matters. We'll continue to follow the E. Jean Carroll case that reopens on Monday, and what happens off of these competing briefings this weekend. One place, MeidasTouch on Legal AF. The title is exactly what you think. It's the leading podcast at the intersection of law, politics, and justice on Wednesdays and Saturdays at 8 p.m. Eastern Time, right here on this YouTube channel. Don't change the dial. Instead, free subscribe to the MeidasTouch network and get them to 2 million free subscribers. Till my next hot take, leave me a thumbs up and a comment here. It helps with the ratings, keeps me on the air. Until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.